And almost all of them preceded the actual meeting with him.
So when you got a copy of the actual complaint that my firm sent to you to let you know that these are the claims that would be filed against John Linetti if the case didn't resolve, you decided at that point that you wouldn't talk to George Benish anymore, correct?
I can't say that that's the timing. I can't say that, sir. I mean, both of those things happen, but from the way you framed your question, it has like a cause and effect implied in it, and I can't say that the cause and effect is true.
You heard George Benish testify that he said that it was during that meeting on June 21st that you told him, or at least that's his best recollection, you told him at that meeting that he would be potentially a precipitate witness and you guys shouldn't talk anymore. You recall that testimony from George Benish?
I do recall the testimony, and I cannot say that Mr. Benish is wrong.
Okay. But you still communicated with him after June 21st?
Not about substantive matters.
And you got a copy of the complaint, strike that. Yeah, you got a copy of the complaint that had not yet been filed, but which named Mr. Linetti as a defendant for me on June 23rd, correct?
I don't know, but it was after I met with Mr. Benish.
Like 2 days after, correct?
If the 23rd is accurate, then yes, 2 days.
Okay. And so after the 23rd, or possibly 21st, you told George Benish, don't do any more work on this case, you might be a witness, correct? It was either the 21st or the 23rd.
I don't know that I said to George Benish, don't do any more work on this case. I don't know that I said that, but I do know that somewhere around either the meeting or shortly thereafter, and I don't know that I even communicated it to George Benish, but I know that in my mind I thought to myself, this man is likely to be a percipient witness to something, and so there's really no way you could hire him long term. And I really didn't need him long term. As you can see, it became obvious to me that I learned enough about the water rights issues that we didn't really need to employ at that point in time somebody to act as an expert witness for purposes of giving testimony. If we did later make that decision, George has percipient knowledge of some things, I think. It appears as though he does. He may, and that being the case, there's no way we can call him as an expert.
So you guys got all of your information from Mr. Benish from the June 21st meeting and any other telephone discussions you had around that time, and didn't need any additional information from any other water attorney, is that correct?
Oh, no, actually, what I learned is that Mr. Siciliano, in his education before the distortion of the mind that's called law school, actually is quite astute in that area. All right, but we didn't know that going in. So he's done a lot of work on this case, specifically on water rights issues. Obviously, he's not going to be an expert witness.
I'm going to read a statement from the opposition that was filed to this motion to disqualify, and I want to ask you a question about it. This was filed by Mr. Linetti through counsel. It says the last written or oral communications by and between Gentile and Benish that involved the substantive issues related to Linetti's retention of Benish was an email from Benish to Gentile at 3:05 p.m. on June 23, 2011, wherein Benish forwarded 2 publicly available VVWD/SNWA agreements which were relevant to the criminal investigation. Is that a correct statement, Mr. Benish, or Mr. Gentile? The last written or oral communications by and between Gentile and Benish that involved the substantive issues was on June 23rd?
There's nothing that comes to mind that would make it incorrect.
Would it surprise you if there were still communications going on with George Benish in July?
Oh, no, it wouldn't surprise me that there were still communications, but they wouldn't have been involved in anything that would be substantive.
Nothing that would be in any way related to this case.
None that I remember.
If there had been, that would have been a problem, right?
Not necessarily. It depends on what the nature of the discussion was.
I mean, you obviously knew at that point. You had read the complaint even naming Linetti. You had previously read the complaint that you knew Linetti had potential liability. You knew about the criminal investigation in the 2008 transaction. If you guys were continuing to talk with Benish with all of that information, you clearly knew that John Linetti was an adverse party to the Virgin Valley Water District. And therefore, if you guys were having discussions with George Benish about anything related to the Virgin Valley Water District's rights, the 2008 agreement with SNWA, that would have been improper, would it not?
I don't think so.
Objection.
Objection.
Your Honor.
Answer that objection.
Thank you, Mr. Gentile, for stopping. He used the word adverse party, and if he's using it in the terms of a party into litigation, the second amended complaint was not filed until July 20th, and the question has a lack of proper foundation. He could not be a party until he was sued.
Well, I think it's a fair question. Maybe it's the way it's being asked. I mean, I think the gist of your question is to Mr. Gentile, asking him for an opinion if any further discussions with Benish would have occurred after on or about July 20th, 2011, which is when the second amended complaint, which first brought Linetti into the civil action, was filed. Would that be appropriate or not? It's a fair question. Is that what you meant to ask him?
Mostly, Judge, I want to clarify that it was when Mr. Gentile received a copy of the complaint that was to be filed, and that was on June 23rd. So that's specifically what I'm saying. Your opposition specifically says the last substantive discussion would have been June 23rd. That was the date you got the complaint from my office that had specifically named Linetti as a party, even if that complaint had not yet been filed, since the parties were potentially going to settle. It would have been certainly no later than June 23rd, would it not? That you knew.
I'm not going to answer that question the way you just put it. Now, if you want to ask me a question, did I receive it on the 23rd? I'll answer that.
And on the 23rd, you knew, you had to know that Virgin Valley Water District and John Linetti were going to potentially be litigants in a case.
Yes, I agree with that. Once
Okay.
I saw a copy of the proposed amended complaint, I knew that.
Okay. So no further discussion should have taken place with George Benish after June 23rd, at the very latest.
Is that a question?
Yes.
I disagree.
No discussion with George Benish about anything related to this case should have taken place after June 23rd.
I disagree. I can't talk to George Benish about anything that would be privileged. And I do agree with that, and I live by it.
But in reality, you guys were still communicating through and into mid-July.
In reality, we did continue to communicate a few times. Yes, but not about anything that was improper.
Nothing that in any way would relate to this case. Is that your testimony?
I can't say that it's nothing that would relate to the case. It might have been, in fact, I do remember one discussion with George because his bill hadn't been paid. All right, and I remember that one pretty vividly, actually. Other than that, I don't remember what we might have talked about.
But if there was further discussion about Virgin Valley Water District and SNWA in the 2008 transaction, those kinds of discussions with George Benish, those would not have been proper.
I disagree. Those would have been perfectly proper as long as I wasn't asking him to disclose anything that he cannot disclose consistent with his ethical obligation to his former client.
Well, the opposition to the motion to disqualify doesn't say that. It says the last written or oral communications by and between Gentile and Benish that involved substantive issues relating to Linetti's retention of Benish was June 23rd.
That's true.